you very much for joining us today at this panel where we will discuss the fight against bias and noise. C'est bon? Is it? Yeah, okay. For those online who may not have heard me, I was just welcoming everyone and thanking you for joining us today for this discussion, this panel about the fight against bias and noise, which unconsciously cloud the counsel and arbitrators' judgment. We are together with 4 distinguished panelists that I will introduce before we start the discussion. First, Vanessa Roux-Collet. Vanessa is CEO Europe and head of the French business at AEW, which is a large real estate investment management company with offices around the world. Prior to this, Vanessa was already at AEW as head of legal in Paris and general secretary responsible for compliance, insurance, and legal matters across European business. Vanessa started her career as a lawyer with Clifford Chance in Paris in the real estate legal department, and you were admitted to the bar about 20 years ago. So Vanessa, you are a business decision maker. Yeah. And you will explain, you will share your views as to how you make decisions, on what grounds, and what do you rely on when it comes to decision making, especially in litigation strategy. Damien Charlotin. Damien is a PhD. You own your PhD from Cambridge University. And in this context, you wrote a thesis about data analysis on authorities in international dispute settlements. You are currently a senior research fellow and lecturer at HEC Paris, and your research focuses on AI and its connection with the law. Your work bridges public international law, international investment law, and AI again with an emphasis on empirical and data-driven approaches. And you describe your role as a scholar as challenging assumptions and uncovering unseen patterns in legal texts and decisions. So, and you also act as a consultant, tribunal secretary on public international law, commercial arbitration matters, and I've been a reporter in international arbitration matters at Plumitif, sorry, for over, excuse me, for over 10 years. Yeah. So you are a scholar specialist with a lot of data and macro view as to decision making, and especially bias and noise that we will discuss. Nicolas Michon, thank you for being with us today. Is a conseiller référendaire, en français dans le texte, or junior justice with the French Supreme Court, the Cour de cassation, serving on the criminal panel of the Cour de cassation. You are trained both in France and in the US, and after clerking for a judge at the district court for the District of Massachusetts, you joined the law firm Debevoise and Plimpton, first in New York and then in the Paris office. You worked as an in-house lawyer for a few years before deciding to train as a judge in France with a career oriented on most parts economic and financial crimes. So Nicolas, you're the judge here today. You are the one who makes legal decisions, and together we will reflect on how you apprehend noise and bias in your decision making. And Maxime is a partner here at Navacelle, and I therefore have the pleasure of working with him on a daily basis. Maxime specializes in business litigation, in particular on international arbitration, commercial litigation in France and abroad, including in the OHADA region. With over 15-year experience, Maxime, you've been involved in cases in various sectors, including energy, construction, and telecoms, both in institutional and ad hoc arbitrations. You also frequently appear before state courts in arbitration-related proceedings, and taken part in internal investigations into allegations of corruption. So in our panel, you are the counsel And as such, your challenge is to identify bias and noise and perhaps try to leverage them to your client's benefits. So before we begin actually the discussion, we would like to invite you to take a few seconds to consider the following question. When was the last time that you were convinced that you were being objective, either in taking a decision or in assessing a situation? Seems an easy one, right? And most of us, especially in the legal field, we like to believe that we are guided by rigor, that we structure our assessments, and this stems from our legal training, our legal education. And this is true no matter where you come from, in which country you are trained. But as lawyers, we are trained to use methodology in our reasoning, to argue rationally, and to decide fairly. And this is something we all have in common here. But everyone here in this room, we have all seen cases where two equally talented teams, two equally skilled teams, reach opposed decisions or assessments. We have all seen cases, instances, excuse me, where tribunal members diverge in surprising ways. Or, so how is it possible? Is it because even when we feel that we are the most disciplined and focused, our judgment can be shaped or clouded by forces that we rarely acknowledge? And this has been uncovered in cognitive sciences and has attracted more attention in the recent years, especially since the publication of the book Noise that we will refer to by Daniel Kahneman, Olivier Sibony, and Cass Sunstein. So these are the notions we want to discuss today, noise and bias, and how do they especially affect arbitration. We will not only examine the notions, but also how they can be measured, managed, reduced, and sometimes leveraged, especially in arbitration disputes. So thank you for joining us. And maybe, Damien, you can give some lights on as to these two notions and how you look at them.
You mean bias and...
bias, I mean bias and noise.
After all, that's the topic of today's panel. Thank you. Yeah, so thank you for starting and introducing the concept and the ideas, and also for introducing the book by Kahneman, Sunstein, and Sibony. Sibony is actually one of my colleagues at HEC Paris, and Sunstein, as you might know, is if not a lawyer, at least an academic in the legal field. So it's quite interesting that you had this range of expertise looking at the concept. They termed it noise, and they probably did very well, because then it became a very successful book, and you could find it in every airport or train station or whatever, because the more scientific noise will be variance, and variance sounds too much like mathematics and statistics, and so no lawyer would ever pick it up. So I'll use the term noise as well, even though sometimes I might sleep and talk about variance. But the way to describe variance is usually and often, and including in this paper I have here, to start with the concept of bias, because everyone understands bias to some extent. Bias is when you see that something or someone is slanted, is directing their attention or their judgment in a particular direction in a systematic manner. There in investment arbitration, we're very common to talk about pro-investors bias, pro-state bias, etc. And that's very interesting here in this definition, because bias, by definition, is directional. It's going in a direction. There is a bias towards something. And that's very important, because it separates it clearly from variance in terms of what it is, but also who to counter it, how to fight it, how to do something against it. Now, in the paper and the way we prepared the talk, I've got here a definition of noise, which says it is the undesirable variability between decisions that should be similar. I'll come back later on undesirable. I think sometimes variance could be desirable, but I'm not second guessing the topic of this talk. But yeah, the main point of variance is that decisions that prima facie, on the face of it, looks sets of circumstances that are similar lead to very different decisions. So if you want bias, that would be the fact that a tribunal will always rule in the same direction for similar litigant or similar situation in one favor of someone against another. Variance would be the fact that you could never predict it. You could never know if a tribunal would rule in favor of the state or the investor, regardless of the merits of a case. The same case with the same strength, the same arguments, suddenly lead to two different decisions. That's noise. Noise, again, then as different from bias, is not directional. The issue with noise is that you cannot predict it. The issue with noise in the legal field is that we all have the intuitions that likes should be treated alike, and that two cases should lead to the same outcome. Otherwise, there is an issue, and especially us lawyers would like to find the cause for any kind of issue, and we sometimes we go for bias. We say that the tribunal is biased against us, but it might actually just be some noise. So the fact that different tribunals will come to different conclusions. I'll give you a very concrete example. In a paper I've authored with Lucy Greenwood and Leonor Diaz-Colteva 4 years ago, we looked at this concept of noise in international arbitration, and we were trying to find one issue where all cases are very similar, and yet tribunals reach very different decisions. And we found a few, but the one we really looked into is interest rate in the investment arbitrations against Spain and Italy. And so you might know that we currently have around 45 cases against Spain arising from their reform of the renewable energy sector in 2013. Something like 30 or 35 of these cases have led to an award, which is more or less public, and so we can see what are the decisions of the tribunals. They differ a lot on their merits, and why not? These are different investment. Somehow they were invested at different times, the lawyers are different, etc., etc. But for those awards that found on the merits for the investors, then there is a question of the interest rate. And then the interest rate to be applied to the quantum of the award does not necessarily, and very rarely actually, arise from the circumstances of the case. You are just trying to put the price of money at a given time. And when we looked at it, out of 25 different awards, only 3 awards picked the same interest rate. We had 19 different interest rates between all the tribunals in circumstances that were very, very similar. Worse than that, some of these interest rates, the tribunals did not notice, were negative. Some of these awards are currently losing money because Spain has not paid a penny. Some of these awards will be doubling in value in 15 years. And so this very particular example of variance, of noise, gives you the really concrete example of what you can do in arbitration. How can you go back to your client and say, well, we won, but you know, they could not agree on an interest rate, and so your award is currently losing value, as opposed to this next investor whose award is gaining value much faster because of compound interest. And we cannot explain it. It's not bias. They're not pro-state or pro-investor. It's just that different people come to different conclusions. Before I finish, just mentioning that arbitration lends itself very well to this kind of variance, because arbitration is by definition a system where we've got ad hoc tribunals or tribunals who always different people on the benches seeing different situations. The rules are different, the applicable law is different. There is very little second level of inquiry. So in judicial systems, you reduce variance by having an appeal, for instance, because if two lower courts disagree, well, you can have an appeal court to set the record straight and have a single solution. We don't have that in arbitration. All arbitrators, all parties have different incentives to change the record and etc. And so yeah, arbitration lends itself very well to variance. How can we reduce it? What can we do with it? Well, I guess that'd be the topic of the rest of this talk.
perhaps before deciding to take the arbitration or litigation route, how do you assess the chances of success of a case, and especially you, Vanessa, when you are to take such decision? What do you rely on? What are your tips?
So just for you to know, as I was an ex-lawyer, it had an influence in the way I'm leading my entity. So just for you to know, I'm leading, so AEW Europe is a big affiliate of Natixis Investment Manager. So we manage around 70 billions of real estate assets in the world. And so I'm taking care of the European part, so half of it. So the first topic I have when I'm having any difficulty, any topic, I'm working for third client most of the time. So maybe it's why I like this entity, like being a lawyer before, working for third party, even though I'm not their lawyer, but sometimes kind of. When I'm looking to a new case, what is quite interesting is to, first of all, listen to the different departments you have in your entity and to see the way they look at it. First of all, you have bias, because some people, they just feel scared that maybe they've done something not correctly, and so they're going to present it in a way which is not really objective. So for me, what is really important is to know whether or not we consider that we have done a fault, or the way we did it was not exactly what we should have done, in order also to know whether we have a chance or not to win in case of litigation or arbitration. Even though, to be frank, we've done mostly litigation more than arbitration, except once. And so the question first is to challenge the different type of department you can have. So you can have legal, technical. You can imagine real estate is building asset, is ESG topic, is asbestos. I don't know how many topic we have. We can have topic with developer, tenant, whatever. So the first point is to get your people around and to try to understand what happened exactly. Before discussing with any lawyer, which is obvious. You know that first of all, you try internally to define what you feel. Even though we know there are bias there also, because I have my own view, I'm coming by my vision. Then we need to also listen to the external people having an impact. What do they think? How they look at it? And then we are choosing who is going to be the right lawyer. Here also we have bias. So in real estate, it's not always the case, but you have some people representing always tenant and other always landlords. So this is not to have any conflict of interest, and they want to make sure that their client will still work for them, even though they are not, even if they are representing the other party. So usually they discuss. So from my side, I'm trying to find the more two topics. For the one technical one, who is really able to understand the problem, where it's coming from. The one also which I like not to take always the same lawyer, right? I like to have several vision and to be able to share. We have a lot of lawyers working for, I think we have an enormous panel. They have specialty, which can be different. And after having listened to all the parties internally, challenging them, trying to define where we go, then we'll listen to our counsel and trying, depending on the one we go in. Sometimes we have pitch with them to see which are the one who can really help us in such matter. And then we discuss with our client, like you do, try to convince them that we think we may win or not. Those are the litigation process currently in real estate, and what do we think, what the Cour de cassation think for this type of topic. I would say that sometimes it's more complex, because it can be a fund located in Germany, in Luxembourg, with assets in France. So then it starts to be more pan-European vision, when it starts to be more difficult. We don't have the same way of analyzing, and we try to share our view. And then we define whether we want a settlement agreement or we want to go in front of trial, if we think we have no chance or we think it's going to be too long because we need to get there. So I think it's all those process who allow me to take the decision of whether we go to litigation Arbitration, it really depends whether it is already in the settlement agreement. It was something what was written there. We don't do so much. It has happened on big deal with, I think, like with big developer. It can happen sometime, but it costs a lot. I don't say litigation is cheap, but I say sometimes arbitration is expensive. But, however, I think it's a good way to do it. And we discuss a lot with Maxime in particular to see when it makes sense and how we can do it. When it's pan-European, really it makes sense. So I would say it's all those process of discussion.
So that's a, multi-factor strategy that you put in place. And it's interesting, you say you may also have bias in choosing a counsel. Yeah. And this echoes at another stage, the selection of arbitrators that, Maxime, maybe you can say a word about.
Sure. Thanks, Roxane. So now that we turn to arbitration, so we just discussed the assessment of a case. During that assessment, as Vanessa explained, there are multiple factors that you take into account. And then once you select the right lawyer, hopefully, then you have to, and you take the decision to start an arbitration, then you're going to have to make one of the most difficult decisions, the most impactful, probably more than what people think, is you need to identify the right arbitrator that you are going to appoint when you have that freedom. Because sometimes, of course, you're not selecting an arbitrator when it's a single arbitrator case, but in most important cases, you will have to appoint, each party will have to appoint one arbitrator, and this is a very, very important decision that the party must make. And in this respect, obviously, you want to make sure, as I just pointed out, to do the right thing, and therefore you want to ensure that your decision is not going to be biased or is not going to be affected by noise or variance. And at that stage, what do lawyers do generally when they try to appoint an arbitrator, when they think of an arbitrator? So obviously, you're going to ask some people around, what do you think of that person? And it's obviously something to do, but it's probably something to do at the last stage of a selection of an arbitrator. If you do it straight away, you're totally influenced. You're going to be totally biased. That's what studies show. You are going to be, if you go and see, what do you think of that arbitrator? You don't give any, you just want to see whether that person who already had that arbitrator in one case, how did it go? And you receive an answer saying, "Oh, that arbitrator was great," or on the other hand, that arbitrator was terrible. That is going to have a major influence that you don't even realize. It's totally unconscious, but it's going to be major, and this may take you to the wrong in the wrong direction. So this is definitely an issue. And also, so for counsel, you have to. And I'm sure we'll talk about it afterwards on how to address this issue. But you also, when you're selecting an arbitrator, you also want to look at the arbitrators themselves and whether you feel they are themselves subject to bias and noise, and whether that's a good thing or not. Damien was referring to the fact that in investment arbitration, you are looking at whether the arbitrators are pro-states or whether they're pro-investors. We all do that. And well, you're looking at arbitrators through those kind of lenses, where you're trying to assess their own bias. So we see that at the selection stage of the arbitrators, there are plenty of bias and noise that come into play, both for counsel but also for the arbitrators themselves.
So there's a selection that's very specific to arbitration if compared to litigation, but perhaps, Nicolas, as a judge, how do you see this process?
Okay, is this working? All right, if you're looking at it from the perspective of what you can do in the process to reduce bias and noise, I'm starting from the premise that as a rule, that's what you want to do. If you're a decision maker, the very first thing that people should realize is that when you're a decision maker, you have all kinds of inputs. I'd compare them to contrary winds. You know, you're on the coast and you have, you know, winds buffeting you left and right, people trying to appeal to various things. And what you want to do, if you want to do your job properly, that is, if you're not just a hired gun who's been put there to rule in favor of the person who put you on the tribunal, is to cancel that out. And what you try to hold on to as a judge or an arbitrator are rules. So it may sound silly, but the very first thing you need to do if you're negotiating an arbitration agreement is to make sure that the rules that the arbitrators have to follow are clear. You know, substantive law, preferably, you know, not putting things in the arbitration agreement that could be contrary. So, you know, this agreement is subject to French law, and, you know, as the procedural rules as clear as you can make them. The more leeway you give to people, the higher the chances that people are just going to go with their biases, which may be biased towards a type of party or a type of reasoning. I could tell you that there are judges that are more sensitive to procedural arguments, others that could go more on the merits, and that's the same with with arbitrators. So substantive and procedural rules, the clearer they are, the more you'll give the decision makers tools that they can use to combat all of that, and we'll come back to that later. The other vital consideration, this is maybe not something I would have said a few years back when I was just a lawyer, because I had never been in a collective decision-making environment. It's what we French judges call collégialité, which is not collegiality in the Anglo-Saxon sense. There is a part of it, but it's not just the cocktail and the coffee. It's what happens to a deliberative process when you have several people, usually 3. At the Cour de cassation, it can go up to 10 or 17 or 40, heaven forbid. I've done that once, not doing it again. And that is that everyone normally will listen to everybody else's perspective, and the end result is usually something that people would not have foreseen, but that normally people will consider to be a good decision. It's actually quite spectacular to see opposing visions clash, sometimes 2, sometimes more than 2, which is where it gets really fun. And the final result is something different, but usually when people take a step back, it's actually not bad. I'm not saying it's perfect, but you can really see that there's another factor in the French way of doing things, which, as you know, we don't have dissenting opinions. The opinions of the individual judges are really secret. You can only access them if basically there's evidence of corruption of somebody on the panel, but that's, from my perspective, a good thing. I'm not a big fan of dissenting opinions, especially for people who haven't been trained in a system where you learn how you do that. So for arbitration, the consequences of that is that the system in which, you know, both parties nominate an arbitrator who nominate the third one, well, in many cases, what you're going to end up with is a solo arbitrator situation where basically the arbitrator that was designated by the party-appointed arbitrators may well take the decision alone if both party arbitrators just rule for their party. So it would seem that if you have an institution designating all of the arbitrators, it should, in theory, be better, but then, you know, those systems can have their own problems.
a clear process, several decision makers. These are elements that can help fight bias or at least diffuse it or reduce it. And here we discussed bias and noise at the very early stage of the selection of who is going to make the decision, but then it doesn't disappear at all. And bias and noise still exist at during the proceedings themselves and at the moment the award or the judicial decision is handed down. Maxime, do you want to?
Yes, so especially in arbitration where as Vanessa pointed out, the stakes in terms of financial investment are pretty high. The decisions to make are generally complex, and therefore it takes a lot of energy, and our brains can play us trick. That's what the studies show once more, and therefore you have some bias and variance that come into play once more. When you have to decide on a complex set of issues, you will try to your brain, without even you noticing it, will try to ensure that you have a coherent story. That's what we call a coherent bias, and therefore, without even noticing it, you are going to overestimate some evidence. You're going to disregard some points that are in front of you just because you want to have a nice-looking decision that makes sense. And this is something quite dangerous as well, depending on which side you are. Obviously, here I'm talking about the arbitrator's view or the counsel that is afraid of the decision to come. So we can see that here again in that process, in the arbitral process, you have bias and noise coming in at that stage. But just to come back on what Nicolas was saying earlier, I was just wondering because the studies again they show that the first one to talk generally is going to anchor in the other's mind an idea. And so I was wondering, when you're saying, well, we are 5 or 6 or 7, I don't know which number you said on the panel, to each talk and take a view. Is there a rule as to who comes to speak first, and does that matter? Because study shows that generally the people who are talking in a meeting when there is no specific rule is the one who is more at ease, and he's obviously influencing, because you're all in the same room, and once someone has said something, it's really harder for the other ones to go against that person's view. So they tend to be more discreet. Is it something that happens in your view?
Well, it's interesting, and it's actually taking us slightly sideways from where I was going to go, but we actually have some pretty definite rules at the Cour de Cassation into how we speak. The order is always the same. The person who prepared the case, the rapporteur, speaks first, always. I'm talking about the deliberations, not the public part of the proceedings, which, because the proceedings are on the papers, are honestly not extremely interesting most of the time. But for the internal deliberation, which is where the sausage gets made, the rapporteur speaks first. Then the dean, the doyen, the most senior judge other than the president of the panel speaks second, and then it goes down in reverse order of seniority, and the presiding judge always speaks last. It's extremely old. It's been codified in the Code de l'Organisation Judiciaire, but to my knowledge, it's always been like that since 1790. And believe me, there's no... the fact that the rapporteur speaks first, yes, that gives that person a chance to set the tone, but everybody will wait to see what the dean has to say. And then if both agree, sometimes one of the senior judges who disagrees will, get a chance to shape the discussion. And the presiding judge speaks last because obviously even though his vote is worth just as much as the others, we don't have a system where the presiding judge's vote is worth more, which means that we can sometimes have tied decisions, in which case we need to go to a larger judging panel. It happens like twice a year, basically. But that's there's always this basic discussion as to whether you speak first or you speak last. I mean, there are even parts of the Bible about the fact that whoever speaks last has an advantage, and it's even codified. This notion that en droit pénal, la parole est à la défense en dernier, la défense à la parole en dernier. So we actually try to balance these two things. Obviously, in an arbitration process, you do whatever you want. And if it's only 3 people, it doesn't matter as much as in a situation where you have 10 people that need to speak, and obviously 17 or 20 or 40. But there's I think it's an almost institutional feel that these are things that matter, and we need to have a process. And sometimes there will be a first round with people taking tentative votes, and then the final vote in a second round where everybody's had a chance to hear everybody's arguments and maybe reflect some more on what was said, and maybe go and check this and that aspect of the case. So I'm hoping I answered your question.
Well, I think it's food for thoughts for all arbitrators who have to deliberate. Thank you.
Damien, perhaps from your studies, can you see whether rules manage to reduce variance in the decision making?
We cannot really see it. I mean, yes, we can say it to some extent, not necessarily rules, but if you want to reduce variance, there is a lot of things you can do. We discussed a few. I'm partial in particular to the idea of collegiality, because it's often the first step in what you should really be doing, because the most variance comes from having a single individuals able to decide arbitrarily, full discretion. That's where you get things all over the place, and sometimes the same individual will decide things differently on different days, etc. So there's an incredible amount of variance. Whereas if you put a lot of different people, normally their biases are supposed to cancel out. Normally, at least you increase the risk, increase not the risk, but the likelihood of bringing enough information to land on what should be, if not the right decisions, because sometimes there is no right decisions, but at least a decision that is most agreeable to everyone. But so that one thing. One other thing that you can do is, well, reduce the amount of discretion. We're not going this way in the legal sector. Over the past decades, we've seen an increasing role for the ideas of proportionality, reasonableness, discretions of the decision makers, and all that gives you more chances for variance. Because if suddenly it used to be the prevailing party gets a cost reimbursed, and suddenly you have to take into account whether they were nice with you, well, now you've got more chances for variance. But that's the trend. Again, we also have all the trends that helps with canalizing decisions, and that's what we lawyers do every day. The guidelines we work on, the academic articles we are writing, the experience, the common experience of everyone, the fact that we're having case after cases which are then published, all that helps with variance, because suddenly we can see what other panels have decided to do, what other arbitrators have decided to adopt, the kind of approaches they have taken, etc., etc. To give you again an example coming from investment arbitration, the ICSID background paper on annulment from 2012, and then they did a new edition in 2016 and 2024, has been tremendously important for ad hoc committees at the ICSID level, in particular for stays of enforcement.
because now you had the data to see, oh, actually most of the time we don't give a stay of enforcement, or actually we put it under a condition or a sanction or something. And then suddenly the amount of the variance in that particular field has started, as far as I'm aware, to decrease, because suddenly we had all these examples. Whereas before that, you were acting without knowing what everyone else was doing. So yeah, we can say it in some ways, but in other ways, it's increasing.
So what I hear is one way to manage or cancel out noise that comes from different person or biases is to gather different opinions, confront different opinions, and balance them out. Vanessa, in your experience, what can we imagine? Like, for example, have you ever tried mock trials with several defense teams to assess whether you were confident enough on a strategy to go to trial, or on the contrary, try to settle earlier?
So first of all, I was just thinking by listening to Nicolas to the fact that what is important also in an entity, because you have hierarchical line with everybody, is just to make sure that, for example, I don't give my view when we start, which is obvious, but you know, sometimes you get to a room and say, okay, I know we did it this way, or I think when you start like that, everybody is going to think your way because they want to make sure you'll be happy with the decision. And this is a big bias, so it's quite important. I was listening to you and saying, okay, I need to make sure that when we are listening to people all around the table, so they are not judges, but they are participating to the decision I'm going to take at the end, make sure everybody give really his view. Conviction is really something I'm talking a lot in my job. I'm the new CEO for 6 months, just for you to know. So it's a new role for me at the European level. And it's really important also to make sure that, and depending where you're working, I mean, if you go to Japan and you have the big boss speaking first, nobody will say the opposite, right? In France, people like to contradict. So in a way, you will always have in the room somebody saying, I disagree. Okay, come on, tell me why. So it's also a way of how you work, where you're coming from, and this is interesting too. You have bias because culturally you're different, which is really interesting when you at my level, when I work with people from Europe, I like the fact that maybe you can limit the bias in a way because people are going to think absolutely differently because they don't have the same background. So thank you for this, because I was just thinking it's really important to make sure that I do not give too much bias, or I do not influence too much the way they're going to think. So as you said, and it is really important. The second point is, what do we want politically to do? Like when you're a big entity, you know that depending on where you want to go, how you're going to do it, the litigation you're going to do, and the result may influence the market where you have maybe quite an influence. So you make sure that when you're going for some decision, you really want to. Maybe you don't want too much noise around it. So I know it's not a very good bias, but just for you to know, it happens quite a lot. So as we say, so it's always very important not to have only legal perspective, just really to be factual, to make sure we have all the factual information. And then we listen to legal people, to lawyers, to know what is our right, what have we done properly or not, and to accept and admit when we've done, for example, a fault or we've done something not properly, it's okay. So people need to feel okay to explain what happens. I mean, even though people do not like to admit. So then the idea of having several lawyers is something that I do sometime, but I'm not very comfortable, but it happens sometime. Alors, either because we have several specialty and we feel people are a bit weak in some part of the deal, so we need to have several one. I don't like it too much because I am always scared to have hole in the loop. So I will take sometime big law firm asking several partners to work together on a topic just to make sure at the end they will say, oh, we didn't know, we thought it was the other one who was doing. So this is very pragmatic topic, but it is one. So sometime when we feel, or I feel that, for example, my lawyer has some bias because he's used only to represent such type of party or he win whatever last big litigation, I could ask to another one, what is your view? Just tell me what you think. We like also to share view of expert. In real estate, we have notary and lawyers. We have some excellent notary also knowing the law, and sometimes it's quite interesting to make the way they look at it. So we do sometime. Do we use IA? That's a good question. So I'm working hard on data currently with all the team because we need to gain in terms of efficiency and also to be able to accept to be challenged. AI is interesting, at least if you know what you're speaking about, because if not, you can really have big problem. But still very interesting if you prompt correctly to challenge that way. And I don't think we do it so much in my entity, but we start to do it by thinking, could AI bring any idea we didn't have for the moment? I suspect also, and I hope that some lawyers do so, because I think it is a tool we have now, so we need to work with it. And then, so regarding the selection of arbitrator, I have once, so I remember the exercise, and it was quite interesting. What is really different is the way you select, the fact that you come to people who knows very well the market, or the rule at least, because for me, the judge, they know the law, I mean globally, and we need to make sure that those are the right person, even though we want to have a more corporate maybe vision, even though some judges have a very good corporate vision, but sometimes this is a mindset just to make sure when it starts to be too difficult, when it comes really to the strict application of law, we feel that maybe arbitration can zoom and help us finding the right solution for the balance of the deal. So on this, I didn't do it very often, so I did it once. And I thought the discussion was very interesting because it was a kind of discussion we didn't have really, because for judge, we don't have it, obviously. It can be sometime decision to whether you want to go in front of such judge or other one, depending where you are situated in France. But beyond this, on arbitration, the decision of defining who is going to take the decision is very specific. And so here you can feel the bias, and we had a lot of discussion internally and with the lawyer. And I think it's complementary, so I think it's a good idea, and it's very important to have it, and at least for European or worldwide topic. But it's so different from the way we do it, and clearly there are much bias because we know we're going to choose somebody who is more or has been more in the business, which gives you maybe another view.
Yeah, if I may just bounce on a few statements that Vanessa made. I was, so when preparing this topic, I saw a few studies which were pretty interesting to me, and the fact that apparently when you say to a lawyer, well, you're going to be acting for claimant, it already has an influence on the way that lawyer is going to see the case. And it's pretty funny because in the studies that I'm referring to, for example, if you take a couple at home and you say, how much do you think you do at home about the couriers? And please give me the answer in percentage. And so the man is going to say, well, I do 40% because honestly my wife does more. And you ask the wife, and the wife says, I'm doing 90%. So obviously there's something wrong here. Well, they ran the same studies with lawyers. So they gave a case, the same case, and they say you're going to be acting for claimant. And to the other person they're making the studies with, they say you're going to act for defendants. And what's the percentage? What are your chances of winning? The claimant says, well, 70%, and the defendant, how much? Well, 60%. Well, it's not possible to get to 130% when you put the two things together. So obviously there is some kind of influence simply by the position that you're being asked to take. And therefore, this is, the way I see it, even as a counsel, not only I'm thinking for the client, but also as a counsel, I see it as pretty dangerous, because that means that we are going as counsel to give advice, a preliminary assessment to our clients on a basis which is apparently, studies say, influenced and biased. And so as a counsel, I think it's, of course, if the client wants to recourse to AI, multiple teams, great, but it's also pretty costly. And that, as a counsel, I can do nothing about it. But what I can do, though, in my team, is that I can ensure that, you know, I'm talking to the associates with whom I work, the other partners with whom I work. We try to confront ideas. And also, you try to fight against yourself a lot, just as to ensure that the bias that you have is diminished in as much as possible, is annihilated. That would be the best. And so, for example, you think this is the key document that's going to be a winner. Well, you take a few steps back, you think about it, and then you realize that, and you ask other people around, what do they think of that evidence? And most of the time, it's pretty interesting because people tell you, well, I don't see why it's that important to you. And you're like very shocked and surprised and say, well, because it's key, look at this, look at that. And just by confronting ideas, I think you can try to diminish the bias that you want to reduce.
If I can add to this, I'm always struck that in the fields of computer science and AI development in particular, we've had for quite some time now the idea for in every research lab to have some people doing something we call red teaming. You're supposed to be part of the red team. You're supposed to take the job of the work of the other people and show that they're full of flaws and etc. And we don't do that in law firms. Whereas that would be very, very useful, actually, to have a designated contradictor. Sometimes you have one. You've got the disagreeable partner who is retired and doesn't care anymore. But not everyone has that. Whereas it's very good, and it's also very good to formalize it because otherwise sometimes it can become very quickly personal and you might not enjoy it. But yeah, more law firms should have people whose only job is to take a brief and say it's really bad, and here is everything I think is bad about it.
So I remember, and I have some former colleagues here in the room with whom we did mock trials sometimes, and I think it's very useful, but there's also a question of cost, and here I'm turning to Vanessa. Do clients are willing to pay, you know, for extra time and for example, a mock trial? I mean, it can be pretty costly, so I guess it all depends of the stakes of the case. Likewise with the AI, yeah, the budget, exactly.
Yes, I mean, the most famous example of that was the internal Anderson breakup, where the stakes were so high that the arbitrators and experts were selected blind, so they were given neutral briefs as what they thought about it. And then the party decided, okay, we're going that way, and we know that we need to use this expert because this is what they truly think about the case, without being contaminated by all of these extraneous factors. Now, in terms of how you go about reducing bias in the decision itself. In arbitration, there are a couple of things that you can do. First, the one thing that's really special about arbitration compared to a judicial process is that arbitration is an ecosystem, an economic ecosystem. So you have relationships that can be good, but they can also be bad. You need to keep your distance with the parties. I mean, there was a very famous annulment of an award due to the way some arbitrator presented his relationship with one of the counsels in an article. I mean, it's not to point a finger at that person, because I'm sure that there are plenty of other examples that maybe did not give rise to an annulment that could have been problematic, as well. Judges are not immune to that. There was a symposium that I could not attend on the impact of career considerations on judges. And that's a story for another time, but this is something that can become problematic in certain configurations. So in terms of structuring the process, there are a couple of things that I think can be useful. In France, we have something called the méthodologie du jugement civil, methodology of the civil judgment, which is the drill that is hammered into you. I have a former colleague in the role at the École nationale de la magistrature, and it may seem silly, but it teaches you how to dissect a case in a certain way, to process the information in a certain way. So what you're supposed to do is to put first in the fact sections the facts that are both relevant and not in controversy, and then to set out a summary of the legally relevant arguments that are put forth by the parties. In practice, 85% of the cases are decided at that stage, because you realize that there's in fact an uncontroverted fact that directly works for one party or the other, and case closed. Cases in which you have an actual factual controversy or legal controversy are rare, quite rare. We have more of them at the Cour de cassation, obviously, but most of the time it's pretty easy. And then, of course, if you have that, then what you've done will help you in your work as an arbitrator focus on those parts of the witness statements and or the cross-examination that actually matter, that you don't need to spend a lot of time chasing down maybe the guy's relying on some minor point, but it's actually not relevant to the case. So having that kind of discipline is quite useful. Something else that's very useful due to what we discussed, anchoring and the fact that whoever speaks first is important. If the arbitrators can each come with a draft opinion to the deliberations, it's useful. Even more useful if they force themselves to write different drafts with different solutions and possibly variants. That's something what we do for cases that are a little bit difficult. I've done it when I was a judge at the Paris court, 2 versions. And at the Cour de cassation, it's more common. It's actually sometimes required that if we have something that goes through the full panel, it's good form to present at least 2 versions, and usually we'll have variants, and very often the discussion will actually be on the variant, because this is what matters, because it forces you to sometimes realize that that thing that you think was so right, well, on peut pas l'écrire, ça tient pas. It doesn't hold together. You just can't write it. You just don't have the evidence, because your impressions are not evidence. And having to put pen to paper, it's cruel sometimes, but it's in my experience, that's not a bad way to do it, but you do need to have arbitrators who are ready to go through that exercise, and it could actually be a good way to select arbitrators and only take those that are ready to do it, except, of course, if you want to have a hired gun on the panel, but then, that's, you don't need a colloque to do it. There are plenty of mercenaries around.
So maybe in the very few minutes we have left, what can we do to leverage bias? How can we use it to our advantage?
Well, I think that's a question for me, right, as a counsel. Because obviously, we've been talking about how to neutralize bias and noise, and but come on, let's be honest. When you're a lawyer, you want to win, and of course, you have to stick to the rules. But the rules do not prevent you from using bias in certain kind of way, or using noise, and there are plenty of examples. And so I'm just going to go through some of them, and I'm sure it will trigger some interesting discussions, probably with the audience here. So, for example, well, we've been talking about the fact that the first impression matters, or that you're going to anchor some ideas into the mind of the arbitrators. So when you're a lawyer, well, there are plenty of ways where you can try to speak first and put an idea inside the arbitrator's mind. You can recourse to emergency arbitration, although here it depends which institution you're dealing with. For example, at the ICC, you're going to go before an emergency arbitrator, but it's not going to be the tribunal. It's going to be different persons. You can, but when the tribunal is constituted, you can ask for provisional measures, and let's be honest here again. When you're asking for provisional measures, it's a small case within a case. You're going to argue the case, you're going to plead, and obviously, even though you're not supposed to deal with the merits, we all do that. We all do talk about the merits at the provisional measure stage, and so you implement or you try to plant a seed into the arbitrator's mind already. Same thing when you request bifurcations. When you request bifurcation, again, you're going to have some very interesting discussions with opposing party, but also with the arbitrators about the strength of a case. And especially if you're asking a bifurcation, if someone is asking a bifurcation between merits and damages, the assessment of damages, that is, you're going to talk a lot about the strength of your case in terms of liability. Security for cost, you can ask as well. So all these are strategies that can be seen as a way to anchor some ideas into the arbitrator's mind. And if you do it well, if you have a skillful counsel, then it will probably be very helpful to the result that you're going to get at the end of the day. So that was one thing I wanted to mention as a tool to, instrumentalize bias and noise. But there are plenty of other things we do as lawyers which create some noise and some bias. Just to give you one example, the way we plead, the way we present arguments, the way we draft our briefs. Some like to put plenty of exclamation marks into their briefs, and they like to write in capital letters and say, well, I'd like to see the studies, whether that works or whether that bothers the arbitrators and the judges more than anything. But at least you can tell that some people are pretty convinced by the fact that this is a noise that they're relying on to make sure that they are convincing enough in the way they present their argument. Of course, the way you plead as well. Using silence, nonverbal communication, we all know, I'm just stating the obvious, but we all know that that plays a role in the way the arbitrators see your case. And also, well, what's great about arbitration is that you can decide plenty of things which you cannot before state courts. For example, you can set up the agenda, and you can agree with the opposing party when you're going to plead. Well, studies show that depending on the side of the table you're at, pleading before or after lunch may have some consequences. So you see, there are plenty of little things which may not seem that important, but at the end of the day, it does have some consequences. And so that's where lawyering skills have their importance. Again, the lawyer is a source of noise, and we're using it. So let's be honest about it. And I think afterwards, it's the arbitrator and the judge role, because even in arbitration, we do appear quite often before judges after the award. It's a fight here. It's a fight where you have the lawyers trying to use bias and noise, and you have the arbitrators and judges fighting against it.
So maybe one last word, and maybe it's for Damien. Is AI gonna solve it all?
Depends on what you mean by solve it all. To replace everyone, maybe, but that would solve it all, no more worries. No, it's very interesting because there are many phenomena at play. When I think about AI and as attached to bias and noise, well, one of the main issues with AI currently is not. We've all heard about hallucination, and hallucination is my beat. I do a lot about hallucination. I've got a database of them. You can check out on my website. But hallucination is really not the big phenomenon that we need to care about. What's really the issue currently is the phenomenon known as sycophancy. The AI is trying to please you all the time. You're so right. That's 100% right, etc. That's very typical answers that AI give and makes complete sense because that's who they're trained.
And that's how they are post-trained, and that's the direction of it. Sycophancy is a huge area of research in the development of AI, and something we're not sure we'll be able to solve fully or to satisfaction, because people love it. In particular, they love to be told they're right. And to that extent that we have this issue with sycophancy and that we don't counter it correctly, well, that will increase bias to a large extent, because you'll be told that you're right, even though you're completely biased. Whereas noise, on the contrary, AI could reduce noise. There is a thing which a lot of recent studies, very interesting, called the artificial hive mind, which is that large language models, which is AI, it's the only technology we're dealing with, they are very similar to a large extent in a number of respects. It's not a question of lacking creativity, because that's not really true anymore. It's more like, by the nature of things, they tend to default to certain answers, to certain ideas, to certain theories of the law, to certain... Just think in terms of the way they write. The way they write is very... not necessarily bad, but very similar, and you can often identify AI writing in a lot of ways. Whereas when you write, you put typos. When I write, there are words that I only know, and nobody knows. There is all these idiosyncrasies that enhance the noise to some extent, whereas AI tends to collapse a lot of what's happening. So that might decrease some noise in terms of the output and what's going on. So at the end of the day, yeah, on balance, I'm not sure it will help much unless, yeah, again, we get all replaced, which I hope one day we'll have that. Working on it.
Thank you all. We still have a few seconds for questions you may have in the room.
Any question?
Je veux bien me dévouer. More of a comment than a question, actually, but to rebound on what Nicolas Michon has said about, I think he mentioned the fact that we were in, arbitrators were in a business ecosystem, which is very right, but it plays both ways, to the extent that if you're regularly acting as an arbitrator, i.e., this is your profession, you make a living out of it. As a co-arbitrator, you said before that if the two co-arbitrators are playing parties advocate, they sort of cancel out each other, and you have a sole arbitrator, which is the president. And the only case in which pleading for the party that appointed you is going to work is only if there's a difference of level or the amount of work you put in the case. Otherwise, there's no interest in being an additional advocate for the party that appointed you. And co-arbitrators also want to have the respect of the president, because today the president was appointed by the co-arbitrators. The next day, maybe the president is a co-arbitrator, can appoint you. And besides that, at the end of the case, if people tell you, oh, I'm looking for an arbitrator, did you sit with XYZ? Oh, it's not the same if you say, oh, he or she was very good, participated in the process, or you say, oh, he was a pain in the butt. He disagreed with everything that didn't go the way of the party that appointed him. So this is a very important element of the ecosystem that puts into check the biases. Where biases may actually be useful, if you're a co-arbitrator and you agree with the decisions and you reach, say, claim number 6 in the award, and you think, oh, for the party that appointed me, I mean, it's a terrible result, but I agree with the result. In terms of reasoning, maybe you're going to try to put in the award additional reasoning, additional paragraphs to show the party that all its main arguments and its relevant evidence were taken into account that did not convince the tribunal for whatever reason. And in that sense, the role played by co-arbitrators could be very helpful to explain to the losing party on each relevant point why they lost. So I think the process, even if you have bias, functions fairly well usually, in my view. There are always accidents, but...
Anyone else? Do you have any questions, or you're starving and you want to have some drinks?
And maybe we can continue the discussions over drink.
Yeah, I think let's do this. Thank you, everyone.